Welcome to Medmark's webinar series. Today's presentation is titled Best Practices to Navigate FDA Enforcement Actions. I'm Kate Klaus, Senior Attorney in Medmark's Risk Management Department. On behalf of Medmark and today's presenter, Jennifer Diaz, thank you for joining us. Jen Diaz is the president and founder of Diaz Trade Law. Jen is a Chambers-ranked, board-certified international attorney specializing in customs and international trade. For more than 17 years, Jen has provided legal advice and customized training on import and export compliance to industry, with a strong record of success in mitigating federal administrative enforcement actions. Jen has received many accolades from the legal community, including being recognized by Super Lawyers as a top international attorney, having an AV rating of superb, and serving as president of the Organization of Women in International Trade. A frequent media commentator, Jen has authored book chapters for the Florida Bar and the American Bar Association, numerous Bloomberg Law articles, and other leading publications. Jen is editor of the Customs and International Trade Law blog, recognized by the U.S. Library of Congress as being an important part of the legal historical record. With that, I am pleased to turn things over to Jen.
Thank you so much for the warm welcome, and thank you all for spending an hour to talk about FDA enforcement, a fun topic. I probably think it's too much fun, but this is the trade nerd side, and I also really love questions and getting engagement. So as you have them, I highly encourage you to pop them into the Q&A box. All of your questions that you did ask upon registration are taken into account and will be gone through during the presentation as well today. So really excited that you are all taking an hour to join today to talk about best practices when navigating FDA enforcement actions because they can be scary. So we'll talk about what they mean, how to deal, how to get the best results when you're dealing with FDA. Big note because a lawyer has to, there's always a disclaimer. Everything we're talking about is generic. Everything that may happen to your particular company is going to be specific. Highly encourage you to have your own counsel as you go through specific examples and to have your own compliance advice that you get for your specific examples makes a big difference. Lot that we're going to cover today. We're going to talk about FDA's enforcement action abilities, all the different things that FDA can do to make your company go down to its knees at times, and how to successfully navigate when those things happen, how to communicate with FDA properly. I love ITACS. We'll talk about it, and everybody's going to have their own portal by the end of this. The actions that you're going to take when you're communicating with FDA and how to appropriately respond when you're receiving an enforcement action, when to get counsel involved, I'll beg of you, and using due diligence platforms. So FDA has a plethora of platforms. We're going to give you lots of useful links as well. So as we go forward, we're also going to do polls, my favorite. So give me 1 second. And it looks like I actually need access to the polls again, if you don't mind. There we go. Perfect. I just found it. So let's relaunch. Give me 1 second, and you should have a poll that just pops up right now. So what best describes you? It's always fun for me to have an ability to see who you are. Are you an importer? Are you a broker? Are you in regulatory affairs? Are you counsel? Are you in product development? Are you a consultant? Are you just curious about FDA and want to learn a little bit more today? So love to get a glimpse of who you are on the line so we can target a little more. Got a lot of brokers in the room, which is a lot of fun, a lot of importers, regulatory affairs professionals, great, some consultants as well. Give you 1 more second to get your votes in, and let's see who the winners are. Ooh, I think the winner is just others interested in FDA, which is super fun. Great, we've got a big mishmash. So I'll talk from every different angle as we speak. Appreciate you guys filling out the polls. We'll have lots more of those as we go on. So when it comes to FDA, FDA has a huge responsibility. Safety, efficacy of all drugs and devices coming into the US to make sure that everyone in the United States that utilizes a device is using a safe, effective device that's not going to hurt them in any way. Big, big, big job. FDA says you better be compliant with FDA rules and regulations before you're exporting the goods to the United States. And that's a huge responsibility, meaning there are some things you can fix post-importation, like labeling, for example, but sometimes FDA doesn't even want you to do that. So we'll talk more about types of issues that we've seen with devices specifically as we go on as well. But I want you to get the picture that FDA's doing this, meaning taking any enforcement action, because there's any glimpse that a device is unsafe for a consumer to use in US commerce. That's their job and their duty, and they take it really seriously. And it's a low standard to stop a good that may appear to be unsafe or not have the efficacy required or not have the good manufacturing practices in place. So when it comes to imports and exports, lawyers like laws, regulations. So whenever you want to look for the laws and or regulations, you're always in Title 21 when it comes to FDA. That's FDA's title in the United States Code. And in the Code of Federal Regulations that implements the laws, you're always going to be in 21 CFR, the Code of Federal Regulations. Lots of leeway for FDA to stop goods, also lots of regulations for device manufacturers, meaning things that you have to do before you can enter the US market, like register your facility, list your device. Those are all things we talked about when we did our MedMark Part 1 presentation on how to market an FDA regulated medical device in the United States and how to make sure that your device is compliant on the first realm. So if you haven't checked that out, I urge you to go back to that webinar because that was more so on registering your facilities, listing your devices, making sure you're checking the right databases to see how your particular device should be regulated and marketed in the United States and complying with good manufacturing practices and so on. Today is going to be more about warning letters and import alerts and detention notices. So as we talk about this, we're going to do another poll, my favorite time. So will give me 1 second and I'm going to launch this second poll for you. And then you're going to tell me, especially for the brokers in the room, I'm looking at you. What are the types of enforcement actions that you've seen or heard Customs or FDA take against your clients or against you as an importer? And don't worry, this is anonymous, so nobody will know that we're talking about you. And there are lots of different things that FDA can do. For example, issue a notice of FDA action, a notice of refusal, which basically stops your product from entering into the US market. That's a big deal. A liquidated damages claim from Customs, those are always up to the amount of your bond in place with US Customs. And that's a big deal because bonds are typically $50,000, but could be more. We've seen bonds that are higher and lick dams that are higher than 50,000. Warning letters are a huge biggie, and it's a public database of warning letters. So it's a public shaming that FDA likes to utilize, and they're Googleable. So that never goes away and is always publicly available. Import alerts, we're going to talk a lot more about as well. And import alerts, we call red light list or black list, lots of different names for import alerts. And it's not pretty when you're on it because you're subject to detention without physical examination. We're going to talk more about that as well. And lastly, recalls. And recalls, not fun at all when you have to withdraw your product from the market entirely. Had a lot of those, especially over COVID, which we talked about as well. So, in your experience, everybody on this call today has seen everything. And we actually have almost a three-way tie. Warning letters and notice of FDA actions are the two biggest, which are the most common. And then we've got recalls is the next highest. And then import alerts and notices of refusals as the third place and lick dams as the fourth place. Thanks so much for participating. It's interesting to see, and since you guys have experience with all of these in some way, shape, or form, we're going to go through all of these and talk more about what action to take. And I will preemptively say for 2 seconds, if you ever get a lick dam notice, which we will go through, never, ever just give away your $50,000 and pay without a fight. And those, we do have substantial opportunity to get mitigated. And if you have 50,000 you just want to give away, then I think all of us at MedMark and me, we're happy to take your donations, but don't ever just give away your money. Instead, give it to your lawyer to fight for you. So let's back up and let's talk about the entry process and the types of enforcement actions that FDA can take. So that was our poll that we just took. You guys have seen all of these things. FDA has lots of rationale in terms of when and why they take these particular actions, but I want to take you through for 2 seconds the import process here. When you'll see, we now utilize what's called predict. It's basically a computer system. Instead of going straight to a compliance officer, we're using a computer system to determine whether or not we're going to take a compliance meeting and not we, meaning not me, but FDA determines whether or not it's going to release your goods and or stop your goods and force a compliance officer to review them at the time your entry filer files your entry. So I want to go back and make sure that that's really clear, because one of the first things that does happen quite a bit is there's poor communication between an importer and a customs broker. Now, I beg of you, on both sides of the fence, if you're a broker and you see your IOR is importing a medical device, you should be yelling at them for the manufacturer's facility registration number, for the device listing number. If you're trying to process and file an entry without those numbers, you're not going to get very far, because FDA has those as mandatory fields when you're filing an entry. If you're an importer, I beg of you to work with your compliance team and or counsel. When we work with our clients that are going to import a medical device, we assist them with the registration setup, ensuring that their device class is the appropriate class, the product code is proper, the registration is proper for their particular device, and that the facilities are listed, the device is listed. We have all of our appropriate numbers in place, and then we include some of those, not all of those, on our commercial invoice. So a practical tip is your actual commercial invoice should have the manufacturer's name and the facility registration number, because that's public. Anybody can have that and can see that on FDA's public database that we went over in our webinar part 1 that's in your chat box. But your device listing number, that's proprietary. Nobody can see that. It's not searchable. So that I don't like putting on an invoice or something that's shareable with multiple parties, because that's a proprietary number. But your broker better have that in order to transmit the entry, because some of the top rationales for why a compliance officer would get involved in the first place is you don't have a registration in FDA system. And that's a great rationale, or the registration number is wrong. One of the other fun issues is if you're giving a broker an incorrect registration number and they're inputting that into the FDA's system, FDA's predict is going to say, I don't see this number in my background. This number doesn't match this facility. We need a manual reviewer to check this out. Now, if you get stuck with a compliance officer having to manually review your entries, if you think that's going to stink and take a long time, you're right. It's not a pleasure for anyone. And it does take quite a bit of time for a manual review to take place. So you don't want that. And if we have to get a facility set up, we can do so in about 1.5 weeks. It's a pretty quick process. The other aspect that many don't realize is if the manufacturer and the exporter are different parties, they both have to be registered with the FDA. That has been a very good rationale for FDA to issue a notice of FDA action saying the right parties aren't registered. I'm not happy. The same thing with the initial importer. The importer of record has to be registered with the FDA separately, and everybody has to pay the fee. Again, all of this was going on in the first webinar in case you missed that. And then the device listing. Those are the most common rationales for detentions of medical devices. Now, when it comes to other issues, good manufacturing practices are huge. And if you don't have those in place, that's a common rationale for a warning letter or for inclusion on an import alert list. Now, other rationales for detention and notices of FDA action are your labeling. Labeling isn't in English. It's false or misleading. If your medical device can cure whatever disease, can it really? And you don't want to make claims that we don't really have scientific evidence to back up. So what I encourage you to do is ensure that your compliance teams have the right steps in place to always make sure our facilities are appropriately registered, our devices are appropriately listed. And when I say facilities, manufacturer / exporter / importer, unless manufacturer and exporter are the same party. Labeling is validated by an expert who can review that labeling, whether that's internal or external. Good manufacturing practices are followed. Until those things are in place, technically, the real question is, are you ready to market? Because if you're not, and if you think you are, FDA has huge detention availability, meaning FDA, as we talked about in the beginning, they need to make sure all devices are safe, right? So what do you think? Can FDA detain products that appear to be in violation of FDA regulations? What do you think? True or false? Take a second. As a thought process that we talked about at the beginning, is FDA's job is to keep us in the United States safe and make sure that all of our devices are effective. So all of you got that right. Great. It's true. The standard is incredibly low in this instance, and that's on purpose. So this is an example. It's an old one, but an oldie but goodie. So in this instance, FDA sends a notice of FDA action. So a couple of things that I like to look at whenever we're looking at notices of FDA action. The first that you'll see the highlight on the top right is what notice number is this? Because I have some clients that show me, hey, notice number 4, it's refused. And I'm like, I need to see all the goods, not just notice number 4. So if you're ever looking at a notice, you always want to take note. Is this 1, 2, 3, 4? And if it's 4, we want to see 1, 2, and 3 before that. Number 2 is the date. And number 3 is when do I have to respond by? Because FDA will give you a certain amount of time to respond. In some instances, they just say, I want to know where these goods are and I want to physically review them, or I want documents. It could be anything for round 1. Now, going backwards, you have an ability to challenge FDA and FDA's determinations during this review process. FDA is going to say, I believe there's an issue. You have the ability to say, I don't believe there's an issue. So something we just went through recently is FDA is reviewing our clients' labeling, for example, and saying, I'm not happy with the labeling. And we're saying, well, we reviewed the labeling and we're very happy with the labeling. Here's why. And we go back and forth with the FDA until we get to a release. Now, there could be many number of reasons in terms of why that particular shipment got stopped and examined in the first place. That's a question we often get. Like, why did I get pulled over? It was your lucky day. Typically, about 1% of your cargo should be intensively examined, meaning pulled over and physically looked at. Should be relatively low. But there are certain triggers for FDA and for US Customs to pull you aside. It could be a new manufacturer, a new product code, a new harmonized tariff schedule classification, a new quantity, a higher value than normal. Those are different risk factors that may come up. A new country of origin, could be a new country you're exporting from, all these fun things. But now, when you have that first notice of FDA action, you have the right to communicate with FDA. So a few things that you should never do. Never just ignore the notice, because that's never a good thing to do. If FDA wants data or documents from you, you communicate with your broker to get those documents. And we'll talk in a few slides about ITACS, which is the tool FDA very much prefers. And I'll tell you why I love it as well when we get there too. This is the time where you get to request extensions. In some instances, let's say, in your particular notice of FDA action, FDA is saying, you didn't register. How dare you? Okay, I need an extension. I'm going to get to it. I'm so sorry. And then we've seen this instance, for example, where an exporter wasn't properly registered with the FDA. So we got the FDA notice of action saying, how dare you? The exporter's not registered. And we said, give us a minute. And we registered the exporter, we got the registration in place, and FDA said, okay, fine. It's something you can correct after the fact. And yes, one of the questions we just got asked is, will I get the slides? And yes, we are going to be nice enough to share slides with you, and hopefully you provide feedback. Usually I'm mean enough to say you have to give us the survey results and feedback in order for us to share slides with you. We'll see. I think MedMark's nicer than me, but no matter what, we will share slides with you. So request your extension from the FDA and discuss how you can fix the issue. In that instance, our exporter wasn't registered. We got the exporter registered. It took us less than 2 weeks to do so, but we requested extra time just to ensure we didn't run out of time. The biggest deal is when you have a notice of FDA action, you have your respond by date on the bottom. That's a very big deal and non-negotiable. Meaning, if you don't request an extension before that respond by date, your goods are going to be refused admission into the United States, and overturning a refusal is a virtual impossibility. We've only been able to successfully do that once when it was an FDA error, meaning FDA refused the goods incorrectly. They never should have been refused in the first place, and we were able to get FDA to overturn that decision. Very uncommon and not something anybody should ever in a million years bank on. What you should bank on is you keeping track of deadlines and ensuring that you're adequately getting these notices of FDA action. Normally, the broker will always get a copy, and all brokers, you must send these to your IORs. And at that time, it's really good to gently nudge them to say, you should really get counsel involved as well, because a broker should not necessarily be an external FDA compliance department to respond to these notices of FDA action. So, importers, if you're pushing your brokers to respond to this for you, know that you're stretching them a little too far, and that's not really what their role should be. And brokers, no offense, but you should be fighting back a little in this instance, and don't let your importer bully you into being their FDA response team. That's not truly what you should be doing unless they're asking for documents and or availability and location of the goods. Absolutely, where we need your help, and we would love it for you to provide that assistance. But if FDA is complaining about labeling or facilities not being registered or GMP is not being followed or any of those other issues we just discussed, then that's not the right place for the broker to have to handle it. So we see a lot of importers saying, my broker, my broker. It's not always the broker. There's a lot of internal responsibility that should be had by the IOR. All right, let's take our next poll. Give me a second and we'll launch this poll. So this is a fun one, and FDA gets a little testy about this. So what do you think? Can the FDA logo be used for private sector materials? What do you think? True or false? And how many of you have seen the FDA logo used on marketing? We see it, unfortunately. Everybody sees it. But how do you think the FDA really feels about it? So I want you to think internally. How many of you have your own brand? How many of you have your own logos? I would assume all of you. So a quick side tip that I want to give you um, is the first step when it comes to your own logo is to register it with the United States Patent and Trademark Office. The second step that not enough people do, I just did a topic on this at a conference, is recording that registered brand with Customs so Customs polices your brand at the border. Happy to talk to any of you offline about that because that's separately quite sexy, because Customs will seize unauthorized goods and issue penalties to those who mess with you and tell you who they are so you could privately go after those entities. Now, FDA feels the same way. FDA's logo is FDA's logo. So 83% of you are 100% right. It is not okay for anyone to use the FDA logo without permission. And this is a notice of FDA action where FDA is yelling at people saying, how dare you use my official logo on your private sector materials? This is not okay. So pretty cool to actually have that in a notice of FDA action. And we happily yelled at our client to rebrand, remarket, and not utilize the FDA logo because FDA is not happy with that in any way, shape, or form. So the second thing that FDA was upset about here was they didn't list the the device in this instance. So that's not okay, and that's an easy fix. And then the last is we're not happy and we're going to refuse your particular device because you didn't file your 510K. So if you want to know more about 510Ks or PMAs or when that's required, then that goes back to webinar number 1 with MedMark that's in the chat box, which we talk about what the pre-admission requirements, the pre-clearance requirements are, and when a 510K is or isn't needed, usually for our class 2 products. So we didn't have a 510K, we didn't have a drug listed, and we used the FDA logo without authorization. So in this instance, we were able to fix the listing, able to fix the labeling, but you can't just fix the 510K. So instead, we were able to argue to the FDA that their class of device that they believed it was different than what we were really marketing it as. So sometimes your argument can be, FDA, you wrongfully think this is a class 2. In reality, it's a class 1 under this product code, and this is how I intended to market this device, and this is how I believe it should be marketed. Sometimes that's the avenue in which you're responding to FDA during the notice of FDA action phase. If this feels like you should have a lawyer doing this, then I beg of you to have a lawyer doing this and making this particular argument to the FDA. All right, next poll. Give me a second and let's launch this baby. All right, everybody better get this one right. You have the right to provide oral or written testimony to the FDA regarding the admissibility of the articles or how you can bring your goods into compliance when you receive a notice of FDA action. What do you think? You have the right to fight and to say, FDA, wait a minute, I'm so sorry I messed up your logo. I'm so sorry I didn't register my facility. I labeled incorrectly. Yes, good. 100% of you. I'm very, very proud. So yes, this is the time. You have the right to provide testimony to the FDA to say, wait a minute, I'm so sorry. Now, that is up until FDA makes an admissibility decision, okay? So let's say we got FDA notice of action number 1, and FDA said you need a 510K and you didn't have it. How dare you? Well, in some instances, that may be true. And maybe we really did need a 510K and we didn't apply for one and we don't have one. That's not good. So what happens is FDA refuses the admission of your medical device. So this is a refusal notice, for example, for gloves in the middle of the pandemic, right? Nobody's seen these before. So now what you'll notice is what happens simultaneous to the FDA's refusal is US Customs demand for redelivery of the goods because that keeps you under your customs bond, which means your liquidated damages or your breach of bond, the fine that you could receive if you don't comply with the refusal is up to the amount of your bond. So all of you importers, I want you to find out one piece of homework. How much is your customs bond? What's the value of that bond? Normally, as I said, it's $50,000. So I want you to think of that. If you were ever to receive a demand for redelivery and a notice of refusal, you've got 90 days in order to export and or destroy your particular goods. And if you don't, you can be assessed liquidated damages, which is usually 3 times the value of your goods up until or capped at the amount of your customs bond, usually that $50,000. So as I discussed a little bit, these notices of refusal, it's not negotiable. So in this particular instance, this refusal, I'm not able to fight the refusal. What I'm able to do is help my clients comply with the refusal notice and ensure we export or destroy within our 90 days. Now, I do want to clarify that the exportation or destruction process is not a pleasant one. Customs requires to be present for the exportation to witness the exportation. What they do is they ensure that the goods that you're exporting are the same as the goods that were refused. Imagine the people that try to substitute the goods. It would never be you, I know, but imagine. So if customs was to catch you trying to substitute different goods and export out different goods than what you brought in, that's a criminal incident. We don't want that. Same thing with FDA. FDA witnesses the destruction of goods. So if you're going to a landfill, FDA will follow you to the landfill. They'll count the goods. They'll review the invoice and the customs entry and the notices of refusal against the goods that are present. They'll review packing lists. They'll review product codes. They'll review SKUs. They'll review whatever they can to ensure that the same goods that are being destroyed are the same goods that you're physically presenting for destruction. We have seen people that have tried to substitute goods. That is a quick sentence into county. You don't want that, because then we get Homeland Security investigators and the criminal side in play, which nobody wants to see. So know that those appointments to coordinate, they can take weeks, if not a month, to coordinate in and of itself. So sometimes finding the right players to export to and or the right dumpsters that'll accept your particular goods, it could take time. That 90 days passes incredibly quickly, and there are no extensions of that 90-day time frame. I was able to have one exception to that, but it's very, very rare. And that's in a time where we had a massive quantity and we needed additional time. But definitely the exception and not the rule. The rule is 90 days or you receive liquidated damages, and the chances of getting extensions in that 90 days are, I would say it's never going to happen, but I can't say never because I was able to do it once. But in that one instance, it was a very extraordinary circumstance. All right. I think these are cool, and these are called compliance dashboards. So FDA gives you a lot of data it used to not give you before. So I wanted you guys to get a glimpse of what companies are seeing and what types of enforcement companies are seeing from the FDA dashboard. So when it comes to inspections, with FDA physically going on site, with the compliance dashboards, you can specify, I want to know more about food, cosmetics, medical devices, tobacco, for example. So what we did was only medical devices. And look, all the way from 2009 to 2024. So these are the top 10 reasons that FDA has been very, very angry when they've inspected companies. And what have they found? And for the most part, it's GMP related, which makes a lot of sense for medical devices. What that means is there were not good manufacturing practices in place. Companies didn't have corrective and preventative controls in place or complaint files in place, GMP related. So this is a good pro tip for all of you on the line to ensure if you're importing a medical device, it's a good time to ensure that the manufacturer truly does have good manufacturing practices in writing, in place, and that if you're importing from that manufacturer, you're auditing that they truly do have GMPs in place, because if they are inspected and they don't have written GMPs in place that they're following, they will likely get a warning letter as a result. So I want to show you on the left side, when it comes to the foreign and domestic inspections, you'll see the majority get what's called no action indicated. That's the green. That means we're happy with them. The red is action. That means not happy. And the reasons that they're not happy are the reasons on the right, for example, like GMP controls, for example. And then the orange is voluntary action indicated, which means FDA is not happy with what they're seeing, but it's something you can fix, and they did fix. So they likely will not get a warning letter or will not get any sort of official finding, but the inspection is public, meaning the fact that you were inspected is always public, and the inspection findings are always what we call FOIA-able. You can, if you have a manufacturer you want to do some due diligence on, you can use FDA's data dashboard, check out that manufacturer, see the fact that there was an inspection, and always get a copy of those inspection findings. No, either way, that's not private. Import summaries are always interesting to look at. It's a crazy amount of import lines, and this is from all time. This is 2002 to 2023. You can separate this out by just 2023, for example, and you can see the lines by year. And for whatever reason, in 2011 it was a crazy spike in lines, but of refused lines, for example. And then we look at the top 5 manufacturing countries. Now, what do you think the top country is? China. What a surprise. So this big red is all China, China, China. Number 2, Mexico. Mexico's a hot number 2. And then we've got Germany, Dominican Republic that are hot, and Canada. So all those are our top 5 within here, and a little bit from other countries like France, Ireland, Puerto Rico, and such. But it's cool to track and trace what our top countries are that are manufacturing. So this was just 2021 to 2024 to get a glimpse again, just more recent importations. And country of origin, what a surprise, largest, China. And then Mexico's our number 2. So we do see some US goods return to the United States. That is common as well. Sometimes goods can leave for repair or replacement or something along those lines, you'll see as well. Now, the types of devices, what's cool is all the different classes of devices and different categories of goods. So general and plastic surgery devices were among the top, along with general hospital and medical. So those are between those two categories, it's almost 70% of medical devices coming into the United States. So you can do this by year and see year after year. You can go back and see history going back as far as 2002 we just looked at before, which is cool that this is all electronic now. What's also interesting to look at are refusals. So we looked at refusals, and if you look, device refusals are pretty freaking high. In comparison, it's the second under human foods. So human foods, 204,000 refusals by product category versus devices, 129,000. This is out of all time. So we didn't specify a specific year, but you can do that. You can go into the data dashboard and specify whatever you'd like and get specific information for the year, for the country and such. But what I'm showing you and what I want you to get out of this is there are a lot of devices that can't come into the United States because FDA says, no, I'm refusing the entry of these particular devices into the United States. And you don't ever want to be one of those. When it comes to recalls, you can see class 1, class 2, class 3 recalls. So class 1, these are recalls that could cause serious injury or death. So class 1, you'll see the green, and thank God that's low, 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 low in comparison because we don't want a whole lot of those. Those are scary. Class 2 can cause a significant or temporary illness, significant injury or temporary illness. That's the majority. Hopefully not death. Class 3, unlikely to cause injury or illness, but are violative. That's the yellow. And those are much, much, much smaller. Normally, we're going to see class 2s when it comes to recalls. So now FDA, if they believe that a product should be off the market, they're going to push a company to perform that particular recall. Now, to back up, we talked about ITACS a little bit at the beginning, and I want everyone to know it and love it the way I do. When it comes to ITACS, a few things that I want to teach you. So ITACS is known for the Import Trade Auxiliary Communication System. Nobody is going to remember that, so I want you to remember ITACS. It's a web-based application, and the idea is you don't have to ask your broker every 3 seconds what the status of that particular entry is with the FDA. You can log into ITACS 24/7 and see whether or not FDA has or has not released your goods. So when I used an entry, for example, can't tell you the entry number because that would be privileged, but I can give you some info here. So I can say, oops, FDA refused the entry. Okay, good to know. What's the country of origin? In this instance, Vietnam. And when did that happen? I get the exact date and I get to see status updates. What happened? Was there documentation requested by FDA or not? Now, when you have your own ITACS account, and when you log into that account, all of the FDA notices that we talked about before, they're actually inside the portal. So you can download them yourself. So if you don't have an ITACS account, when you want to create your own, you do create new account. And when you're in it, our step-by-step guide here is once you're in, you make sure that other FDA systems on the bottom, ITACS is checked off. You can also do your own prior notice here. Usually brokers are the ones submitting prior notice on behalf of their importers. If you don't know how to, I would entrust your broker to submit your prior notice on your behalf, but I would highly recommend you to get ITACS access. That means that you'll be able to always have access to the FDA notices, and you're able to create sub-accounts as well, which is never a bad thing. And you're also able to respond to the FDA. Now, technically, you can respond to the FDA in ITACS without having your own account. But if you're able to log in, you can always get those notices. So no matter what, I highly recommend you get your account, log in, communicate with FDA that way, and just makes it a little bit easier to ensure that you're always getting the notices and you can always flag your particular entries and see the status of those entries at any time when it comes to ITACS. Now, when we get notices of FDA action, when we're responding to the FDA in terms of another best practice, we actually always put the submission in ITACS and also email the FDA. It's a best practice to do both because what if the person that's assigned to your particular entry is out on leave, sick, whatever the case may be? If you put it in ITACS, it could get read by another reviewer. It always gets flagged as entered, so you never have a late submission. You always have that receipt, and the email itself may or may not make it to the right person who's actually in the office. The ITACS submission always will be flagged for your particular entry as well. So the best practice is to always respond in ITACS and additionally via email. We try to always do both. Now, if you get your notice of refusal from the FDA, for example, in this instance, this is, for example, notice number 3. So if we were to read notice number 1 and 2, because the first thing I taught you, if you ever get this notice, you say, wait a minute, I need you to show me 1 and 2. What went wrong here? What could we have done differently? Are we ever going to import this again? Like sometimes you have shipments on the water and you know that this is a bad shipment that FDA didn't clear. Well, maybe I want to turn that next one around before it has the same issue. Maybe we don't want to enter that. So you want to start thinking of that when you get these notices and start creating your 90 days. Your 90-day window, we've got to go through exportation or destruction. And remember, you're always subject to that CBP redelivery. And for example, we have a joint team in Miami called Joint Team 488. Every port has different instructions. So this is our Miami instructions on what they expect. But remember, your port could be different, could have different instructions, could have a different team, a different email, a different instruction on who to call to witness the exportation or to witness the destruction. This is something that has to be done in coordination with your broker, because your broker will have the location of the goods and can help to coordinate these particular appointments, because they're not a pleasure to coordinate. Sometimes there's quite a bit of back and forth to get these appointments set. So that 90 days again comes up incredibly quickly. So we want to ensure that, I would say you got your first 30 days to decide if you're going to export or destroy, and you have your last 60 days to coordinate both. And you have to make sure you get your signed form back witnessing either the exportation or destruction. And that's your proof that the exportation or destruction occurred under supervision. That is your ticket to get out of the lick dam issue. Otherwise, if you don't export or destroy within the 90 days, or don't export or destroy with signed confirmation from FDA and/or Customs, you do get a liquidated damages claim. Now, the notice took out the juicy parts for you, says I'm demanding $50,000. And remember, $50,000 is the max because that is your Customs bond maximum amount. And it'll say, this is your lick dam. Why? Because you didn't export or destroy refused goods within the 90 days I gave you to do so. So then what the lick dam notice also says is, if you feel there are extenuating circumstance, then you've got 60 days to file a petition. That's a biggie as well. So then we file petitions with Customs, and it's interesting because US Customs is the one who reviews the petition and then gives you a final decision. So for example, this is a decision letter from Customs redacted heavily saying this is in response to your petition. We issued a liquidated damages because there was a misbranding issue. The goods were refused. You had 90 days and we're really annoyed. You didn't export or destroy within the 90 days, but you did export or destroy, so we're going to give you mitigation. That is typical. So now I have my next poll for you. Let's see how you guys do in your next poll, and then I'll tell you how this all works out. So does Customs typically go back to the FDA and follow the FDA's recommendation as to the amount acceptable to cancel the liquidated damages claim? Do you think that Customs takes over the case, or do you think Customs then goes back to the FDA to say, FDA, these are FDA regulated goods. FDA, what do you think in regards to this case? Most people usually get this one wrong. All right, I'm gonna ask one more time so we can get some more votes in. It's about almost an even split here, which is interesting. So do you think when Customs issues the liquidated damages notice, and then we respond with our petition within our 60-day window, does Customs, that basically there's a paralegal assigned from the US Customs side, does that paralegal then go back to Customs to say, Customs, okay, wait a minute, I need FDA's opinion. There's an FDA underlying issue going on for these particular goods. Does Customs then say, wait, FDA, what do you think about the underlying entry? Do you like this guy? Do you think this guy followed your instruction? So it's a half and half with you guys. And the real answer is true. And the reality is during the petition process, you've got your 60 days to respond. And we highly recommend that you respond and you fight, and you never pay without that fight. But Customs will always go back to FDA because the underlying issue is the FDA refusal. Customs doesn't have beef with your goods. You didn't follow Customs' demand to redeliver your goods and to export or destroy on time, but the underlying true issue with the gloves, with the whatever device, was that you didn't follow an FDA regulation or procedure in some way, shape, or form. You didn't list, you didn't file your 510K, whatever it is. So customs will always go back to FDA, ask for FDA's guidance, and then customs follows FDA's guidance. All right, let's see which one. Let's see if you guys can get this one. So when it comes time to export or destroy, all right, this one is no launch. Perfect. Which of the following is not true? What do you think? A previous record of compliance is correctly a mitigating factor. It's an example of a mitigating factor for your petitions. Goods must be exported or destroyed within 90 days of refusal. If goods are exported after refusal, the exportation has to be done under customs supervision. If goods are destroyed, the destruction must be done under customs supervision. Which one do you think it is? This one's a little tricky. All right, we got votes for all of them. So most of you, looks like, are doing the right one. So the good news for you is there are what we call mitigating factors when you file your LICDAM petition. Mitigating factors are a huge deal, and some of the rationales for mitigating factors are, I never messed up before. So a previous record of compliance is absolutely an example of a mitigating factor, because this is which one is incorrect instead of correct. So this was a little tricky. So the majority of you actually got this one right. The right answer is D. So if goods are destroyed after FDA refusal, your job is to coordinate an appointment with FDA, not customs. So customs witnesses exportation and FDA witnesses destruction. And if your goods are refused, you only have 90 days to export or destroy. That is our non-negotiable deadline. All right, when it comes to compliance actions, I wanted to go over warning letters with you in a little more depth because this is a hot topic. When it comes to warning letters, there are a lot of them that get issued every year. It's not a crazy number, but this is, almost all time, 2009 to 2024, 1,600 warning letters. It's a lot of warning letters, but these are just for medical device facilities. And there's a lot of different rationale for warning letters, but I want to give you some feedback. If you ever are in a position to receive a warning letter, which is never a fun thing, there are a lot of things you have to do. Number one is those 15 days to respond. Those are non-negotiable, but you can get an extension. But you have to justify why you do need more time. But you have to be in touch with the FDA within those 15 days. And that 15 days is nothing. That time flies. Once you understand that upper management is committed and in control, you have to get the right team in place. It's a biggie. Upper management has to know about warning letters because remember, this is as public as it could possibly be. It's a very, very big deal. The letter is going to be addressed to top level management, and the response has to be a top tier response as well. You're assigning your own response team, and everyone has to be calm, supportive, rational, and controlling. You've got to develop your plan. Usually, you're going to have counsel involved in this, and there should be internal and external stakeholders. If things are done incorrectly, you want to ensure you have privilege. So if you have external stakeholders, I usually coordinate them via counsel. So if we have external auditors that come in, we want them auditing from counsel auditing, meaning your agreement with external lawyers, the lawyer then hires the auditors, so the auditor's findings are privileged, and the lawyer decides what to or not to disclose to the FDA. That's a biggie. The warning letter has to be taken seriously, and you have to understand what message the agency is sending and getting an adequate response in place, because if the warning letter has a serious underlying issue, you may or may not be able to address it with just your response. You usually have more corrective action that you need to take. So getting in the right legal counsel, keeping your privilege in line, hugely important. Making sure you are protecting public safety and your product safety is also huge. Like what corrective action should be indicated. Those are big deals. every issue in the warning letter has to be addressed, and you should be responding in descending order of importance. Like the most important issue is what should be reported on first and discussed first. And identifying and responding to each finding individually is huge. Sometimes we need an auditing team to go on site if there's a GMP issue. For example, we need our own independent auditors to physically audit your manufacturing process, your GMP program, to figure out what happened. Maybe there's a critical control that's not in place. Maybe the machines aren't being cleaned properly. Maybe raw material ingredients aren't being tested and controlled properly. Whatever the situation is, sometimes it's a cleanliness issue, and your team itself leaves the manufacturing facility and comes back and doesn't wash their hands, put on appropriate gloves. Whatever the issue is that FDA found to issue this particular warning letter, you really have to have good corrective actions to make sure that FDA now doesn't feel like you're a problem child. Because once you get this warning letter, it is possible for FDA to clear your name, and to usually the warning letter is accompanied by your placement on an import alert list. Those usually go hand in hand because that's FDA's way to automatically stop your importations from just clearing in the United States when they come in. So let's do our next poll. Let's see how you guys do. And you'll be sad to know this is your last poll. So once you're placed on an import alert list, is it impossible to be removed? True or false? What do you think? Once you get your bad warning letter and you're automatically on our import alert list, can you get off the import alert list, or is it impossible? And I will say, to some people, it feels impossible. So for example, if it's a GMP issue, it could be that FDA physically has to go to your site and then audit that your GMP issues are taken care of before you get off that import alert list. So sometimes it does feel like it's impossible. The majority of you got that right, in that you can get off the import alert list. There's absolutely a process to do so. So the same way you got on the import alert list is the way in which you can get off the import alert list, meaning one is the import alerts are searchable by industry, by country, by product categories. So you can see these are all of our different industry groups within devices. You can search all of them. So the import alert list, sometimes there's a green list, means these are the firms that are okay to clear without being stopped. And the red list is these are the automatic stop. You've got to stop first. So for example, for detention without physical examination, for false or misleading claims. So, and I want you to notice that even Canada and Canadian firms can be on an import alert list. This is not just a China problem or one particular country problem. Every country and everyone's at risk for being placed on an import alert list, regardless of how much we love your country otherwise, regardless of our free trade agreements. So these are firms in Canada that said, for example, on a product, use my product for effective treatment in earwax buildup. Use my product for hearing problems, sinus congestion, or frequent migraines and earaches. Now, what happens is this claim can't be substantiated. Maybe they don't have any findings to substantiate this particular claim, or maybe they're making a drug claim on a medical product, and that gets you into drug land as well. Or the next one's even worse. And this is another Canadian firm that said, use my product because it promotes better hearing, and it also gives you better lymphatic circulation, and it'll also give you some pressure regulation if you use my ear product. Now, these guys, for example, they made these claims in 1996 and 1997, and guess what? They're still on the import alert list today, meaning this doesn't just go away. If you don't fix the issue, then you can't get off the import alert list. Now, how to fix the issue is we go to the detention without physical examination section of FDA's import and regulatory procedures manual. And typically, we've got to do a couple of things. One is if it's GMP related, you've got to do a really great audit. If it's labeling related, maybe we're just fixing our labeling and taking off our misleading claims that we don't have the scientific evidence to back up. And maybe it's just deleting FDA's logo from our site. That's great. That's an easy one. And maybe it's harder, like the GMP issues. Now, you usually need 5 consecutive non-violative shipments. But remember, if you have a GMP issue, those are going to be a lot harder to get through because you've got to correct your audits. You've got to make sure that FDA is going to feel like your particular importations are safe and effective. So we've got to respond to that warning letter in conjunction and then get FDA to start testing your particular shipments again. That's not an easy process to go through, but it's not an impossibility. When we go through this, ultimately, for example, we had a detention without physical examination, an import alert for illegal or undeclared colors for a product, for example. We file a petition for the removal from the import alert list, and we get back our letters saying, okay, you met the criteria, you're good to go, and you get off the import alert list. Now, does that always happen? No. So what should you be doing? No matter what, you should always be checking the FDA data dashboard. This is where we got all of our cool history, and this is also where we can do due diligence on any manufacturer. It's a phenomenal tool. So you can search the data dashboard and find out whether or not there have been inspections, recalls, refusals, compliance actions. You can get all of the dirt there. There are so many useful links that FDA has in play as well that I've summarized for you. By the end of this, all of you are going to have your ITACS account. You're going to look at FDA's regulatory procedures manual, I hope. You're going to use FDA's data dashboard. And we've got lots of other great resources here. Labeling for medical devices, it's a big issue, and it's an avoidable issue. You don't want to have your goods detained and or refused and or be put on an import alert list for labeling. You want to make sure that you fix that. The way to fix that is to ensure that that's reviewed prior to importation. We've got lots of on-demand webinars, surviving audits, for example. We've got great newsletter that's once a month out. We've got a blog that's once a week out, and we talk about UDIs, for example. MOCRA is a big topic right now for cosmetics, whatever you're into. We talk about that, and we have to keep up with all of these crazy agencies. So we do have the cutest dog in the world. This is Lucky. He's our head of security. So if you ever come visit me in Miami, you get to meet Lucky. He's a Tibetan Terrier, the cutest little head of security at DTL, and lots of different ways to keep in touch with us. And I know we had one question that I do want to answer. And if you guys have any others, then please feel free to put them into the Q&A box, and happy to review them. And I know we're just about out of time as well. And if you ever want to keep in touch and send me questions privately as well, would love to stay connected. Definitely on LinkedIn. We're on all the other fabulous platforms. We're always putting something on LinkedIn, Insta, Twitter, Facebook, and so on. I know MedMark asks you for your feedback after this webinar as well. So I do want to encourage Kate to ask you for your feedback and future webinar topics that you have in mind, because there are so many different avenues that you can go. For example, GMPs is always a huge one, and it's a very easy one to mess up. So we want to ensure that you get that. You get that right. Thank you. Somebody just said something nice in the Q&A box, which I will take. Great presentation. I appreciate that. Any good comments or good feedback, we're always happy to take as well. So I do encourage all of you to keep in touch. And if you do have any questions that you do want to ask privately, then please feel free to do so. I'm Jen at diaztradelaw.com. My info is here and our numbers here. And we look forward to hopefully seeing you guys again at MedMark, and always really thankful for having us with you at MedMark. So huge thanks to Kate and the entire team for having us. And hopefully we answered all of your questions that you asked in registration we talked about during the presentation today. So a huge thanks again for having me. I hope everybody enjoyed us. Oh, thanks. I'm glad you guys enjoyed the polls and enjoyed the webinar. Thank you guys. I love the comments and Q&A, so keep them coming.
Thank you so much, Jen. If you have 1 minute, we did have a question come in during the registration process that was interesting to us. It was with regard to interaction with FDA in in-person meetings. How much and what kind of information should companies be providing in these meetings?
My question is always with or without counsel, because quite often clients love to talk and FDA loves to get you talking. So I'll always ask you, who is at that meeting? So if FDA is coming to you and they have an OCI person, an investigator, they're looking at you criminally. So I beg of you to say not a damn word and have your counsel there quickly, because that gets very scary very quickly. If FDA ever asks you to sign an affidavit, say, wait a minute, I need to speak to counsel first. That is where I would not talk all that fast. When FDA is typically coming to you, normally there's a problem and they're not happy with something. So I beg of you, I beg to not dig a hole so deep that your lawyer can't get you out of, because we charge triple for that versus calling us immediately to say, this just happened. What do I say? What do I do? Can you interact with FDA? Having counsel interact with FDA directly makes life a lot better, because we know what to say and, more importantly, what not to say. Because quite often you can give too much information. And remember, everything you give to FDA can and will be used against you. So be careful.
Thank you. It's 3:01, so I think we have taken up enough of your time for today. Jen, thank you so much for the presentation. This is such an important topic for our industry, and I know your expertise will be really valuable for our listeners.
It was a pleasure. Thanks, everyone. Have a great day.
Thank you for joining us. This concludes today's webinar.